Welcome back to the deep dive. The world of engineering and construction contracts can feel like, well, like navigating an ancient, sprawling city filled with dense documents, endless appendices, and really complex procedures.
It can. And what if you're running a project where time is tight, the risk is contained,
Yeah,
and the last thing you want is a legal text thicker than your project manual?
exactly. That's a real problem.
And that's precisely the gap that FIDI, the International Federation of Consulting Engineers, aims to fill with its simplified suite of contracts. I mean, historically, if you wanted a robust, internationally recognized contract, you defaulted to the red or yellow books.
Which bring heavy, heavy administrative obligations with them.
Oh, absolutely. And for many projects, the small to medium-sized ones, the quick builds or the repetitive works, that heavy administrative lifting is total overkill.
Right. So today we are focusing on the simplest, most streamlined path FIDI offers. We're doing a comprehensive exploration of the FIDIC Green Book, the short form of contract, second edition, 2021.
And our mission, really, is to take you deep inside this document. We want to understand exactly when you should reach for the Green Book, what kind of project it fits.
And most importantly,
And most importantly, we are going to break down the purpose and content of its 14 general conditions clauses. We want to extract the critical nuggets of knowledge so you can apply this stuff immediately.
we've got a lot to cover. This 2021 edition is a significant step up from its predecessor. It feels like it acknowledges that people have been using the Green Book for far more complex work than it was originally intended for.
That's the key.
So let's frame this. What exactly does the Green Book 2021 represent in the greater FIDI ecosystem?
Well, think of it as the agile alternative. It's explicitly designed as a shorter, less administratively demanding contract compared to the Red Book or the Yellow Book.
Which are the big ones.
The big ones, yeah. So if you are approaching a project where the value is moderate, say anything from a few million up to maybe $20 million, or where the work is inherently simple or highly repetitive, the Green Book is your starting point.
I noticed the structure reflects that intent for simplicity. It's highly manageable. It's just the form of contract agreement, the general conditions,
Which is what we're diving into.
the 14 clauses, right? Then the particular conditions where you tailor the contract and the guidance notes. It's concise and focused.
And what's really critical is understanding the shift from the 1999 version. The original Green Book had these hard quantitative limits. It was intended for works under $500,000 US or lasting less than 6 months.
That's tiny by today's standards.
Tiny. But commercial reality intervened. Parties loved the administrative ease and started using it for projects that sometimes exceeded $10 million. So FDLIK had to catch up.
So the 2021 edition effectively just tossed out those arbitrary numerical limits.
Threw them out. It embraced the reality that it's suitable for small to medium value works, whatever that budget happens to be.
And with that scale-up came the necessary sophistication.
Exactly. The new edition introduces a few key layers of structure that were entirely absent before. The two biggest additions that make this a truly robust contract are, first, the formal introduction of an engineer to administer the contract.
A role previously handled ad hoc by the employer?
Often, yes.
Okay.
And second, a formalized claims procedure with defined time limits. It adds a level of rigor that just wasn't there before.
The formal engineer is a huge change. It lends professional credibility to the administration. But the mechanism that keeps jumping out at me is the prolongation cost mechanism. That sounds like a specific calculated shortcut.
Oh, it is.
It's designed to avoid the biggest arguments in construction. How much are my overheads worth when you delay me?
It is a game changer. The prolongation cost mechanism, which we will unpack in detail later, is a sophisticated, pre-calculated daily rate for non-site specific overheads. It's FIDIC's attempt to preempt those lengthy, costly, and often really contentious substantiation processes.
So it's simplicity backed by an agreed upon formula.
You've got it.
Okay, before we dissect those 14 clauses, let's nail down the decision point for you, the listener. When is the Green Book the undisputed champion over the red or yellow?
Well, the intention is built around administrative ease and proportional risk. It's for projects where the employer or the project management team wants to avoid committing significant resources to contract administration and management.
Or just where the perceived level of risk is low?
Exactly. It's designed for parties who value a smooth process over absolute, minute control.
I've heard it called the Get On With It contract, and that makes total sense. It focuses on the essential provisions, cutting out a lot of the early warning systems, the detailed financial reporting, and complex notice procedures that characterize the longer books.
Quicker execution, less paperwork. That's the idea.
And that administrative lightness is driven by incredible flexibility, especially regarding design responsibility.
It is. The larger FEDI contracts are highly prescriptive. Red is traditionally employer-designed. Yellow is contractor-designed. The Green Book is amphibious. It can handle either.
And that is a crucial difference because risk allocation is fundamentally tied to design. I mean, if the employer provides the design, the contractor assumes execution risk, but not design risk.
But if the contractor assumes the design responsibility, they take on a much higher risk burden. The Green Book accommodates both. If the contractor takes on design, which must be clearly stipulated in subclause 4.7, contractor's design, the contract explicitly sets out an obligation of fitness for purpose.
And fitness for purpose is a higher bar, isn't it? It's not just about conforming to specs.
It's a much higher bar. It means the contractor guarantees the design will meet the intended operational use. This flexibility allows the Green Book to serve as a simple alternative across a huge spectrum of procurement models.
It extends that flexibility right into the commercial realm, specifically payment. You mentioned a comparison earlier to NEC4 contracts.
I did, and it's a vital comparison for users familiar with modern contract management. In the more rigid FID forms, payment methods are often fixed. Here, the Green Book allows the parties to select from several different valuation options to fit the work.
So the contract is entirely modular in terms of payment.
Pretty much.
Walk us through those options. When would you choose one over the other in a medium-sized project context?
Okay, first you have the lump sum option. This is great for a well-defined scope, say a standard office fit-out. You can structure with a single payment, stage payments based on milestones, or sometimes with a bill of quantities for minor adjustments.
In a second.
Second, you have the remeasurement option with a bill of quantities. You would choose this if the exact quantities can't be precisely determined upfront. Think bulk earthworks or underground utilities where the final volume might change.
So lump sum minimizes employer risk if the scope is perfect, and remeasurement is for scope uncertainty. What about the third option?
That's the cost-plus method. This is where the contractor is reimbursed for their actual verified cost, plus an agreed-upon fee for overheads and profit. You'd use this when the scope is highly uncertain, maybe for emergency repairs or very early exploratory work.
Where a lump sum would just be a wild guess.
Exactly. And the Green Book allows for any combination of these options within the same contract. You could have a lump sum for the foundation, remeasurement for the piping, and cost plus for unexpected remediation. That level of commercial control is essential.
That ability to mix and match really does make it a powerful tool for sophisticated but fast procurement. It's designed to be user-friendly, adaptable, but still legally robust. Adaptability established. Let's jump into the 14 general conditions, starting with the absolute bedrock in Clause 1, General Provisions. This is where we establish the dictionary and the legal ground rules.
Clause 1 sets the indispensable language. It kicks off with Subclause 1.1, definitions. If you misunderstand a core term, you misunderstand the entire contract. You've got adjudicator, commencement date, contract price, and crucially, the base date.
Okay, hang on. The base date, it's defined as 28 days before the latest date for tender submission. Why is that specific date so critical? It seems academic.
It seems it, but it carries enormous risk implications. It's the invisible line that divides who carries the risk for future changes. It establishes the baseline for pricing and for environmental conditions. For instance, it's essential when defining unforeseeable.
And unforeseeable is defined as something that could not reasonably have been foreseen by an experienced contractor by that base date.
Precisely. Let's take a hypothetical. If, after the base date, but before the commencement date, a new environmental law is passed that significantly increases the cost of waste disposal, a law that wasn't reasonably foreseeable, the contractor may have a claim.
But if it was foreseeable, the risk lies with the contractor.
You've got it. The definition hinges on that base date. We also established the definition of an exceptional event here, the force majeure catch-all for events beyond a party's control.
Moving from definitions to operations, subclause 1.3, communications, lays out the administrative flow. Everything in writing in the contract language takes effect upon receipt. The crucial nugget here, I think, is that communication must not be unreasonably withheld or delayed.
That phrase is surprisingly powerful. It's an implied duty of good faith administration. It prevents a party from deliberately sitting on a necessary approval just to frustrate the other side.
Which is core to the whole Green Book philosophy.
Absolutely. We also established the legal context via Subclause 1.4, governing law and compliance with laws under Subclause 1.7.
And if there's a paperwork conflict?
Subclause 1.5, priority and errors, maintains order. It establishes a document hierarchy. The contract agreement usually prevails. And if there's an ambiguity, the engineer has the duty to issue a clarification or instruction, quickly resolving the conflict.
Before we hit the big financial safety net, there's Subclause 1.9, intellectual property. How does FIDI balance ownership of designs and drawings?
It's pretty straightforward. IP created before the contract stays with the creator, but the contractor grants the employer a non-terminable, transferable, non-exclusive, royalty-free license to use those documents for everything related to the works.
So the employer can still operate and maintain their building even if the contractor is long gone.
Exactly. It ensures they retain the rights necessary to operate their physical asset.
That makes perfect sense. Now the big safety feature, Subclause 1.10, limitation of liability. In the 1999 version, this was often missing, wasn't it?
It was, and it was a problem. This was a recognition of commercial fairness. Without a cap, a minor failure could bankrupt a firm. So now the total liability of the contractor is generally capped at the sum stated in the contract data, or if not stated, the contract price.
But I'm guessing there must be exceptions to that cap.
There are, and they are critical. The liability limit is removed entirely in cases of fraud, gross negligence, deliberate default, or reckless misconduct. If you act maliciously, the contractual cap offers you no protection.
A powerful deterrent. That brings us neatly to the second major player, the employer, outlined in Clause 2. The employer has duties to ensure the contractor can actually do the work.
And the most basic, non-negotiable duty is in Subclause 2.1, access and possession of the site. The employer must grant access and possession within 14 days of the commencement date, unless specified otherwise. A breach of this is a classic cause of delay claims.
So if the employer is still dealing with tenant issues on day 15, the contractor immediately has grounds for an extension of time and cost.
Immediately. The contract provides teeth to that deadline. And the employer must also share information under Subclause 2.2, site data. They must make available all relevant data they have, topography, subsurface, hydrological data.
But the contractor can't just blindly rely on that data, can they?
Correct. The contractor is deemed to have examined and been satisfied with this data before submitting their tender. The employer provides the known facts, but the contractor, as the expert, is expected to assess those facts.
The final, and arguably most important duty for the employer is the financial guarantor in Subclause 2.3, financial arrangements.
This is pure contractor protection. The employer must provide reasonable evidence of their financial arrangements to pay for the job within 28 days of a request. It assures the contractor they aren't committing millions to a party that might default.
Which brings us to the third core party and the big addition in the 2021 Green Book, the engineer, defined in Clause 3.
The formal provision for the engineer is a huge leap in sophistication. It professionalizes the whole contract administration process.
But here's the nuance. While the engineer is a skilled professional, Subclause 3.2 explicitly states they are deemed to act for the employer. How do you balance that with the need for impartiality?
It's a point of frequent discussion. They're an agent of the employer, but they have a contractual duty to act as a skilled professional, which implies objectivity. And practically, their authority is streamlined. If employer consent is needed and not refused within a specified period, that consent is deemed given.
So the employers can't just use silence to block things.
Exactly. It prevents administrative gridlock. The contractor's primary interaction is through instructions, stipulated in Subclause 3.3. Compliance is mandatory.
But the engineer's most critical role isn't just giving instructions, is it? It's avoiding disputes.
Yes, through Subclause 3.5, agreement or determination. The engineer is required to try to reach an agreement with both parties on any matter. This is the first step in dispute resolution.
And if they can't agree?
The engineer must issue a fair determination. They act as the inaugural internal adjudicator. Notice of that determination must be given within 42 days with supporting details. It's an early-stage filter before things get formal.
It seems like FIDI is building in layers of increasing formality, negotiation, engineer determination, then formal dispute resolution. That's clever project management built right into the contract. We've established the framework and the roles. Now we define the contractor's responsibilities, the actual execution, starting with Clause 4, the contractor core obligations.
Subclause 4.1, general obligations, is the mandate. execute the works, provide supervision, use appropriate goods, conform to laws, and be responsible for site stability and safety.
And, crucially, the contractor is responsible for correcting errors in their own documents.
That's a key point, especially if they hold design responsibility. Accountability is centralized through the contractor's representative in subclause 4.2. This person must be named, authorized, qualified, and fluent in the communication language.
They're the legal face of the contractor on site.
That's right. Then we hit a huge risk transfer moment in subclause 4.3, contractor's care of the works. The contractor assumes full responsibility for the care of the site and the works until the taking over certificate is issued.
So if a major storm hits the uncompleted structure, who pays for the damage?
Unless that storm qualifies as a specific employer's risk, like an exceptional event, the contractor pays. They are responsible for the physical safety and repair of the works until the employer formally accepts them.
Moving to financial reassurance, subclause 4.5, performance security, ensures the contractor puts skin in the game. They must deliver this security within 28 days.
And the rules for claiming against that security are highly constrained to protect the contractor from frivolous claims. The employer can only claim if the contractor fails to pay the employer, terminates in default, or fails to extend the validity.
And the security must be returned swiftly.
Within 21 days after the engineer issues the performance certificate, and if the contractor is designing, subclause 4.6, contractor's documents, addresses the review cycle. Documents are submitted and the engineer reviews them and issues a no objection.
That no objection is a permission slip.
It is. If the engineer fails to object within the review period, no objection is deemed given. But the critical rule is the contractor cannot commence work related to documents that haven't received that approval. It's fundamental quality control.
That focus on pre-execution approval leads directly into Clause 5, quality, safety, and remedying defects.
Quality expectations are set high, but simply in subclause 5.1, manner of execution. The works must be executed in a workmanlike and careful manner in accordance with recognized good practice. It's a global common sense standard.
And given modern realities, subclause 5.2, health, safety, and environment, is mandatory.
Of course. Compliance with all applicable HSE laws. The employer's oversight right is in subclause 5.4, inspection and testing. Both the employer and engineer must have access to inspect and test.
If a flaw appears later, during the post-completion defects notification period, or DNP, subclause 5.5, remedying defects kicks in, the engineer instructs the fix.
And if the contractor fails to follow that instruction, the employer gains two very powerful and commercially balanced levers.
Which are?
Option 1, the employer remedies the defect themselves at the contractor's cost. Option 2, and this is where commercial judgment comes in, the employer can choose to accept the defect in exchange for a reasonable reduction in the contract price.
That second option is important. If the defect is minor or fixing it would cause massive disruption.
Exactly. The parties can agree to a financial settlement and move on. It promotes pragmatism. And once all defects are fixed and the DNP expires, the engineer issues the final stamp of approval in subclause 5.6, performance certificate.
The paperwork is done, quality certified, and the project moves into its operational phase. Time is the universal currency of construction, and failure to manage it triggers big penalties. We move now to Clause 6, time execution, program, and EOT.
Subclause 6.1, execution, sets the initial tempo. The contractor must commence execution within 28 days of the commencement date notice and proceed diligently to complete within the time for completion. That's the key deadline.
To manage that deadline, planning is required in subclause 6.2, program. The initial program must be submitted within 14 days.
The engineer reviews it within 14 days. If the plan is unrealistic or fails to comply with the contract, they can reject it, forcing a swift resubmission.
I really appreciate the addition of subclause 6.3, advance warning. It's mandatory for both parties and the engineer to advise the others of any known or probable future events that might cause delay or increase cost.
It shifts the focus from fault finding after the event to mitigation before the damage occurs. It's a genuine risk management tool. When delays are unavoidable, subclause 6.4, extension of time for completion, EOT, provides the relief mechanism.
What are the primary grounds for an EOT under the Green Book?
The contractor is entitled to relief for anything caused by the employer's risks from Clause 11, any variations from Clause 7, or exceptional events from subclause 6.6. This ensures the contractor is only held accountable for delays within their control.
And if the contractor is the cause of the delay, subclause 6.5, delay damages, applies.
The employer is entitled to liquidated damages calculated daily, But the crucial protection for the contractor is the damages are subject to a maximum amount, which must be stated in the contract data. This protects them from unlimited exposure.
Let's look at the termination trigger related to force majeure in subclause 6.6 exceptional events.
This provides a clear, objective exit ramp. If an exceptional event prevents execution for 84 continuous days, or for multiple periods totaling more than 140 days, either party may issue a notice to terminate.
So no one is trapped in an indefinitely suspended project.
Exactly. Assuming the project continues, changes are a certainty. That leads us to Clause 7, Variations, Rights, and Valuation.
Subclause 7.1, right to vary, empowers the engineer to initiate variations.
It does. The contractor must respond by submitting a proposal for adjusting both the time for completion and the contract price.
Now, a key point for protecting the contractor. The engineer's power to vary is capped. What are the limits?
The engineer cannot instruct a variation that omits work, which the employer intends to carry out itself, that prevents poaching. They also can't instruct a variation that is unforeseeable in scope or nature, or one that adversely affects safety compliance.
If a variation is validly instructed, we look at pricing under subclause 7.2, valuation of variations. We have a pricing hierarchy.
Lump sum agreement first, then existing contract rates, then day work rates, and finally cost plus profit. But here is where the brilliance of the 2021 Green Book really shines.
Go on.
Subclause 7.2.3 mandates that the valuation of variations must take into account the associated prolongation cost, if any. This is a game changer.
Okay, let's pause there. Prolongation cost. That sounds specific and new. What exactly is that?
When a variation or compensable delay occurs, a contractor incurs two types of costs: direct costs and indirect costs, or prolongation. Traditionally, substantiating prolongation, which includes site supervision, temporary facilities, and head office overheads, requires complex financial archaeology.
Right, they have to submit massive claims using intricate formulas, which are difficult to calculate and often challenge.
And that's the problem. The Green Book requires the parties to define, in the particular conditions, a fixed daily rate or formula for this overhead recovery before the work even starts.
So it's pre-agreed.
It's pre-agreed. They might agree that the prolongation cost for overheads is, say, $5,000 per day of compensable delay. When the engineer issues a certificate for a variation that includes an EOT, the payment simply includes that fixed daily rate multiplied by the approved days.
It eliminates months of negotiation and argument.
It transforms an expensive forensic accounting exercise into a simple arithmetic one. That is precisely the kind of efficiency that makes this contract so attractive.
Now for the financial clauses, starting with Clause 8. Payment the financial flow. The foundational rule, subclause 8.1, just reminds us that payment must follow the commercial options specified.
Right, and we often see an advance payment mechanism covered in subclause 8.2. If included, it's an interest-free loan to the contractor to cover mobilization and initial cash flow needs. It has to be secured by a guarantee, of course.
And the repayment doesn't start until the contractor is well into the work, right?
Correct. Repayment commences when the aggregate amount certified reaches 25% of the contract price. It's then deducted proportionally from subsequent interim payments.
The payment schedule is set out in subclauses 8.3 and 8.4. It's a structured process. Contractor submits a statement. The engineer issues a certificate within 14 days.
And the employer must pay within 28 days of receiving both. That 28-day window is critical. And standard practice governs subclause 8.5, release of retention money. First half after taking over, second half after the performance certificate.
Now for the two big financial incentives. First, subclause 8.7, delayed payment. If the employer misses that 28-day deadline, the contractor gets financing charges.
And the rate is specific and high, acting as a real deterrent. It's compounded monthly, at the annual rate of 3% above the discount rate of the central bank. If the central bank rate is 5%, the contractor is owed 8% interest, compounded monthly.
That's a powerful disincentive for the employer to drag their feet. It's not a token penalty.
Not at all. The second novelty addresses modern instability. Subclause 8.8, changes in cost. This addresses volatility, particularly inflation. If the parties agree the price should be adjusted for rises or falls in costs, the precise calculation methodology must be stated in the contract data.
Essential in a world with supply chain shocks.
It neutralizes a massive source of future claims.
Excellent. Shifting gears from money to exposure, we delve into Clause 11. Risk and responsibility. Who carries the burden? This is the core of risk allocation.
This clause is the blueprint for who claims what. If the contractor encounters an employer's risk, they are entitled to cost plus profit and or an EOT.
Let's detail some of the specific crucial employer's risks under subclause 11.1.3.
These include loss or damage from an exceptional event, interference by the employer's personnel, specific war events, certain unforeseeable natural physical conditions.
Like unknown geology.
Exactly. Also design defects attributable to the employer and unforeseeable adverse actions by local authorities. These are risks that fundamentally belong to the party procuring the work.
And we circle back to the overhead recovery here, right? If the contractor is entitled to cost plus profit and EOT due to an employer's risk, that compensation automatically includes the prolongation cost.
It creates a seamless link. The moment an employer's risk is identified and causes a delay, the compensation is determined by a pre-agreed formula, not by a protracted negotiation.
Conversely, the contractor manages all other risks. However, they are entitled to relief for cost due to a change in law.
Correct. They don't have to predict future legislation. Finally, mutual protection is covered by subclause 11.3, indemnities. This is standard. Both parties indemnify the other against third-party claims for injury, property damage, and so on, but only to the extent it's their own fault.
To protect against those losses, we move to Clause 12, insurance protecting the works.
Subclause 12.1, extent of cover, dictates that the insuring party must secure cover in the joint names of the parties. This ensures both have protection under the same policy.
And what's the consequence of failing to secure that critical coverage?
Subclause 12.2, failure to insure provides a cure. If one party defaults, the other party may insure the works themselves, pay the premium, and claim that payment back. It's a mechanism to ensure the ultimate catastrophe and uninsured loss never happens.
The physical work is nearing completion. We now address the formal handover in Clause 9, taking over formal acceptance.
Subclause 9.1, completion, defines the trigger. The contractor applies for a taking over certificate when they believe the works are substantially complete, all documents are submitted, and tests are done.
The engineer then has a 28-day window to respond under Subclause 9.2. They either issue the certificate or reject the application detailing what's outstanding.
An issuance of that certificate is monumental. It constitutes the employer's formal acceptance, transfers responsibility back to the employer, and marks the beginning of the defects notification period.
I find Subclause 9.3, taking over parts of the works, fascinating because it addresses practical operational needs.
It's key for phased projects. If a road needs to be opened, the employer can accept that specific part early. But there's a vital protection for the contractor. The employer is explicitly prohibited from using any part of the works until that part has been certified.
Which prevents them from using the asset while shifting the risk back onto the contractor.
Precisely. We shift now to the breakdown phase. Clause 10, suspension and termination. Subclause 10.1, suspension, grants the engineer the power to halt the work.
For what reasons?
If they can't certify payment, if the employer fails to pay, if the employer fails to provide financial arrangements, or if there's a material default by the contractor.
If the issue is irreparable, the employer can terminate under Subclause 10.2. What constitutes a material breach?
Typical breaches include the contractor failing to remedy a default, illegal subcontracting, assigning without consent, or becoming bankrupt or insolvent.
And the contractor's right to terminate is outlined in Subclause 10.3.
This protects the contractor from an intractable employer. Grounds include the employer failing to remedy a default, failing to provide financial arrangements, or engaging in fraud.
Here is where the 2021 Green Book introduces the second huge novelty, designed for simplification. Fixed liquidated damages on termination, detailed in Subclause 10.4.1.
This is a major departure from the standard FIDIC books where a loss must be proven. Here, if the employer terminates for cause, so a contractor default, the employer is entitled to amount equivalent to a flat 20% of the value of the works not executed at the date of termination.
Let's put numbers to that. Say it's a $10 million project, and the contractor defaults when it's 60% complete. $4 million of work remains.
Then the employer immediately gets 20% of that $4 million, or $800,000, as liquidated damages for their lost profit and consequential loss. They don't have to hire forensic accountants to prove it.
It greatly reduces the legal friction and cost.
It's a risk-reward calculation. The employer might lose out if their actual loss was 30%, but they save all the legal costs of proving it.
And the contractor gets a similar benefit if the tables are turned.
They do. If the contractor terminates for employer default, or if the employer terminates for convenience, the contractor is entitled to an amount equivalent to 10% of the value of the parts not executed.
So that 10% serves as their fixed loss of profit.
Exactly. For a simpler contract form, This fixed percentage mechanism is perhaps the clearest reflection of FIDIC's intent to streamline legal closure. You know the price of termination before you even sign the contract.
Given the increasing formality of the 2021 edition, it makes sense that Clause 13 claims is now a fully structured process. Subclause 13.1 grants a party the right to claim for additional payment, EOT, or relief.
And the structure is strict. Subclause 13.2, claim procedure, mandates that the claiming party must give notice within a tight time frame, 28 days of becoming aware of the event. This notice must then be followed by a fully detailed claim within 84 days.
Now, this is where listeners familiar with the 2017 red or yellow books need to pay attention. The green book takes a significantly softer approach to late notice, doesn't it?
It does, and that's the crucial distinction. The standard FIDI contracts generally mandate forfeiture. You miss the 28-day window, you lose the claim entirely.
Which is very harsh.
Very. It reflects the target audience of the Green Book, smaller firms, who may not have dedicated claims managers. Subclause 13.2.2 states that if a party fails to provide timely notice, the engineer must take account of the extent, if any, to which the failure has prevented or prejudiced proper investigation of the claim.
So missing the deadline doesn't automatically kill the claim. It just means the engineer has to assess how much harm the delay actually caused the other side.
Exactly. It's a less punitive, more pragmatic test based on causation and prejudice rather than an automatic administrative guillotine. However, even with that softer approach, Subclause 13.3, duty to mitigate, is non-negotiable. Both parties have to try to minimize the effects of claim events.
Finally, we reach the last clause, Clause 14, disputes adjudication and arbitration. If the engineer's determination is disputed, the parties move to formal resolution.
Subclause 14.1, adjudication, requires disputes to be referred to a single adjudicator, jointly appointed by the parties. The 2021 edition even expands the adjudicator's role to include informal assistance to encourage proactive dispute avoidance.
The adjudicator's decision is immediately binding, correct?
Correct. Subclause 14.1.5 makes the decision binding, even if a party gives a notice of dissatisfaction. The decision must be followed, and if a party fails to comply, the other can seek enforcement directly in arbitration.
And if the dispute remains unsettled, it escalates to arbitration via Subclause 14.2. And here again, FIDI streamlines the process.
They do. They recognize that complex three-arbitrator panels are too expensive for these types of contracts. So the new Green Book provides for a sole arbitrator and stipulates that proceedings should be conducted under the ICC Expedited Procedure Rules.
Using the ICC Expedited Rules means the timeline is severely compressed, saving months and massive legal fees. That focus on speed and efficiency really is the ultimate purpose of this contract.
It is. The appendix on the adjudicator's agreement also reinforces balance and independence. Every mechanism in this final clause is built for swift, proportional resolution.
Okay, let's unpack this and bring it all together. We started this deep dive looking for a streamlined contract, and the 2021 Green Book delivers, but not by being dumbed down. It's no longer just for tiny jobs.
Not at all. It's a flexible, robust contract for small to medium value projects that successfully integrates formal administration, like the engineer, with clear, simplified procedures.
It successfully bridges the gap between administrative simplicity and legal robustness.
And the key novel mechanisms we discussed, the specific, predetermined liquidated damages for termination, the 20% and 10%.
And that defined prolongation cost mechanism.
Exactly. They are not just legal quirks, they are commercially brilliant shortcuts. They bypass the enormous time and cost involved in traditional loss substantiation, making the whole resolution process faster and cheaper.
The Green Book is the ideal choice when administrative overhead would be disproportionate to the project's risk or value. You get an internationally recognized contract without drowning in paperwork.
However, this pursuit of simplicity through technical formulas introduces a fascinating legal complexity that listeners need to be aware of.
Meaning
Meaning that while the contract itself simplifies the substantiation of loss, it can shift the legal fight to a more fundamental level.
Go on.
When you predetermine highly specific costs, like the fixed daily prolongation costs or the 20% termination damage, you risk moving the legal challenge away from, did the contractor prove their $1.2 million loss, to the more fundamental question, is this fixed 20% formula actually valid and enforceable under local laws governing penalty clauses and liquidated damages?
You're challenging the very foundation of the contract's simplification.
Potentially.
That's a profound observation. Does trying to simplify the cost calculation formula just give rise to a potentially more existential legal challenge down the line? It
Mhm.
requires careful drafting of those particular conditions to ensure the fixed costs are justifiable estimates of genuine loss.
It certainly does.
Something for you to consider as you tailor the Green Book for your next efficient medium-sized project?
Absolutely. The devil, as always, is in the particulars and the local jurisdiction.
Thanks for joining us on the deep dive. We'll catch you next time.
If you want to learn more about managing a Green Book contract, then watch our contract administration video. Or if you are interested in by the administration templates, then visit our shop. Links are also in the description. Thanks for watching.